No.
SJC-10303, Linehan v. Linehan.
Good morning, Mr. Malil.
Good morning, Chief Justice and Justices. May it please the Court. I'll be brief this morning or this afternoon because this matter is unopposed. Just briefly, I represent the trustees of a trust, Patricia Linehan, Scully Linehan, and BNY Mellon, in a declaratory judgment action. And we seek a judgment from this Court because tax consequences may flow from whether or not...
Do you have any idea that there will be any? I mean, has either the federal or state taxing authorities indicated to anyone connected to this family that there may be a problem here?
Here the concern is just federal, and it has not been expressed yet, but there are substantial sums involved here. And independent of the tax issue, the trustee simply needs to know who to distribute the funds to. If the exercise of the power was invalid, then they would distribute the funds directly to the children of the power holder, whereas if the exercise of the
Where
power...
are the funds right now?
The trustee continues to hold them, waiting a ruling from this Court. But given there's...
So you're asking for instructions?
No, we're seeking a declaration that the exercise was in fact valid.
But you can't have a declaration that, I mean, as a general matter, you can't have a declaratory judgment ruling. I mean, declaratory judgment rulings are very unusual, and there has to be, a controversy. Here there doesn't seem to be a controversy. And essentially, to put Justice Cordes in a different way, you're asking for an advisory opinion of this Court.
I would respectfully disagree, Chief Justice. There is a real question here, and there's a real concern because of the wording used in the power of appointment, and that the specific
Well, the
wording
trustee
in the
may
trust...
think that there's a real question, and he's asking for advice. And we don't usually do that. He can exercise his fiduciary duty, take an action, and if there is an objection to the action that he's taking, then there's a controversy.
The problem is it will be too late at that point. If the funds are distributed in trust, which is what the trustee is seeking a declaration, should in fact
Couldn't he
happen
seek
here.
instructions in the probate court, though, if
No.
there's some confusion?
Well, what we need, though, is a declaration from this Court.
That's
because
for the
there is-
Internal Revenue Service.
Under
There's
the
nothing.
Bosch decision.
Yeah, but that's
correct.
for the Internal Revenue Service, and there's nothing to suggest that the Internal Revenue Service has the remotest interest here. Correct?
Well, they were given notice. We did send them by certified mail a copy of the complaint. But again, the concern is there's approximately $12 million in this trust, and if the service were to look at this and conclude that the power was not valid, then there would be severely adverse tax consequences that would flow to the children of the power holder. There could be significant gift tax consequences. The IRS could assert that the children have made gifts to their mother and to their own children. There could be significant estate tax consequences. The IRS could assert that these assets are in fact includable in their taxable estates. And for those reasons, a trustee is not in a position to distribute the funds in trust without a declaration from this Court that in fact, under Massachusetts law, that's proper.
But if you went to the probate court and sought instructions, and the probate court said, under the terms of the trust, it's pretty clear that because of the language that power of appointment could be exercised to create another trust.
Mm-hmm.
No, you don't have a Bosch kind of binding declaration, but you've got a ruling that seems to. I mean, you're trying to combine two things here, aren't you? Both the IRS and I guess you're saying that the trustees are confused as to what to do.
Well, I think the trustees are concerned that there could be an ambiguity construed in the terms of the power of appointment. But it's the trustees' position that what was intended here was to enable a distribution in further trust. And what leads it to that conclusion is a statement by an attorney for the firm where it was drafted, saying that when we use that wording, that's what we needed. But I think people could read that free of all trust wording to perhaps require an outright distribution, and that's the core of the concern. And again, given the substantial sums involved here, and the potentially negative adverse tax consequences, the trustees really feel that a declaration is needed in order to carry out its
And the
fiduciary
negative
duty.
tax consequences are to the children?
To the children, that's right. So Donald Scully, the holder of the power, has 4 children. If the IRS could take the position that the power of appointment, in fact, only allowed an outright distribution to those children's acquiescence in the trustee instead placing the assets into a trust of which they're beneficiaries along with their mother could be deemed a gift from them to their mother, and it could also result in those assets being taxed in their estates when they don't actually have the funds.
Mr. Miller, let me suggest this. There are cases that we have where it is clear on the record that an instrument, trust or some other instrument, was drafted in order to avoid federal taxes, let's say.
Mm-hmm.
And it is clear that as drafted, either because there's been a change in the law or because the lawyer was incompetent,
Right.
that the present law would result, if the executor proceeded as directed, that there would be enormous tax consequences. In those narrow circumstances, we have from time to time permitted the retroactive amendment as long as it is consistent with the whoever created the instrument's intent. This case strikes me as being beyond that, namely, one possible reading, exercising a fiduciary duty, is the way your trustee would like to act. And maybe the IRS will come in and challenge that. Why would it not be appropriate at that point to then bring, a prompt action to say this has been challenged and we'd like to have, let's say, the probate court judgment affirmed?
The problem is one of timing. If the trustees simply distributed the funds in trust, as Donald prescribed in his will, there would be no notice to the IRS at that point in time that it had been done. It would only come up much later on when Donald's children passed away, and if their estates were audited and the IRS went back and looked, and this could be many, many, many years down the road, the money would already have been distributed, the money would be gone, it would be too late for anyone to come back to this court and say, now tell us that that was okay. The proper point in time to do this is before the trustees distribute the funds.
Do you know can you give me any other case when we've done that? In
Where-
these circumstances? I'm not talking about when we've revised a trust instrument, we've done that from time to time, but where there's not a clear, there's some ambiguity in the instrument. I mean, there's often an ambiguity in an instrument. There's frequently an ambiguity
Right.
in an instrument.
And the concern here is that one could certainly argue that there is an ambiguity in this instrument, particularly the use of free of all trusts, because free of all trusts could be argued to mean simply distribute it outright, completely, into the hands of...
Is there clear evidence that it was structured this way in order to minimize or obviate the payment of federal taxes?
The problem is the donor of the trust is long deceased.
No.
The
but-
drafting
I mean,
attorney...
we always are dealing with donors who are long deceased, right? But is there some evidence that he was trying to avoid tax consequences?
Well, as I mentioned in a footnote, unfortunately, the firm that drafted the trust can't locate their file. The donor of the trust is dead. The drafting attorney is dead. There's no records, there's no papers, there's no letters, there's no notes, there's no nothing because the firm that drew it up can't find their file. One can presume, given the sums involved here, that reduction and avoidance of tax was certainly an objective. But unfortunately, I cannot tell you that we have any hard evidence to confirm that presumption. I see my time is almost up. Again, I would urge the court to rule on this matter. Again, it's an issue of timing. If the court makes the parties wait until the IRS raises it, that could be at a point in time when it's simply too late to remedy the situation.
Sure.
Thank you.
Thank you, Mr. Morrell.
All right.